gentlemen. Ready to proceed?
Yes, Your Honor.
Okay. The next case is All-Star Bail Bonds v. District Court, case 62866. Mr. Sheets is here for the petitioners. You ready to go?
Yes, Your Honor.
All right. Please proceed.
I could respectfully request a couple of minutes for rebuttal at the end.
Well, it would be appropriate, but no reply was filed, so there's no rebuttal allowed.
I was not aware that in a writ circumstance that there was a procedural allowance for a reply absent the court's request.
Right, there is. Go ahead.
Good morning, Your Honor. I appreciate being given the opportunities to speak with you here today on behalf of my client, All-Star Bail Bonds. This is an interesting case because I believe it poses a question of first impression before the courts this morning. One of those questions of first impression is whether or not deportation under NRS 178.509 requires formal proceedings through a criminal court, through an immigration court or a federal court, and deportation by those means. Another issue is whether or not a bond may be exonerated or deemed unfulfillable or as a contract unenforceable because of common law contract offenses.
The deportation issue is very interesting because we have a situation where the party voluntarily left the United States and wasn't allowed to re-enter, opposed to being excluded from the United States.
Yes, Your Honor, I could not agree more. And while there is a case that deals with an individual who's left Mexico in this court voluntarily and voluntarily decided not to return and dues bail bonds, in this circumstance the facts are very, very different. In this circumstance we have an individual who was, and from the very beginning I just to give a little bit of background, he's booked into the Clark County Detention Center. He's booked on a felony charge. When he's booked on the charge, as occurs in all bookings in the Clark County Detention Center or most, there's an immigration person on site who reviews and determines whether or not to place an ICE hold. A hold is not placed on the defendant. At that point he is then able to post his bond. Post his bond is released, has a lawful visa to travel. He travels back after his first sentencing because of a continuance. When he goes to come back, at that point, pursuant to the records that were provided to us by Homeland Security, he was arrested, placed into handcuffs, searched, and then he was interrogated.
Why did the bond company let him leave? Why did they let him leave?
Well, with all due respect, the bond company's job is to assess the risk of flight when it comes to a defendant and whether or not they're going to return. A bonding company has no reason to believe that the individual doesn't still have the right to travel back and forth between the country of Mexico when he's booked into the Clark County Detention Center, he's released without a hold on him. Immigration did not place a hold on him, knowing that there's an immigration representative there inside the Clark County Detention Center facility. And normally individuals with visas are generally entitled to post an immigration bond and start proceedings in immigration court, and that can occur. They can proceed in that process and they can travel freely within the United States when that occurs. And there's no reason, absent an ICE hold, to believe that his visa could be revoked, considering his visa remained outstanding up until the point when he decided to re-enter.
Did they not remember post 9/11 what's going on in this country with strengthening our borders and all the other stuff that goes on? I mean, you pay your money and you take your chances when you're a bond company. And they certainly could have said to this guy, don't leave town.
And I think, that's a fair statement that a bond company could say you're not supposed to leave town, but generally, absent any legal basis, bonding companies don't want to start restricting people to individual cities, especially when a court didn't even feel the need to do that in this instance. In this instance, the court did not place him on house arrest. The courts did not feel the need, and I'm talking about the trial court, did not feel the need to keep him here locally. They never placed travel restrictions on him. They never asked him to surrender his passport. They never inquired as to his visa status. They never asked him to revoke that visa status. And I think when we have a court that's taking that position, you have ICE that's already had an opportunity to look at it and has not placed a hold on him, and then you're in a situation where he's traveling on a lawful visa. There's no reason why a bonding company should expect that there's going to be a problem unless we would imply that they should have an immigration lawyer standing by at every second telling them, oh, it's possible that something could be revoked here. But even the records, as you see from Homeland Security, they didn't even make an official determination. It said it appears that he's not eligible for admission, and then they withdrew his application with the sergeant's approval, and then they sent him back and revoked his visa at that time. At the time the bonding company issued the bond, they based their risk assessment on the belief that he was legally entitled to travel, and that was based on what occurred at the Clark County Detention Center and not placing the hold, what occurred at the 8th Judicial District Court and then not placing the restrictions on him, and then his possession of the valid visa, which they had seen and witnessed. And based on that, they believed that this individual had the freedom to travel back and forth. And generally under the provisions, or at least as it goes when it comes to immigration, until that conviction has actually occurred, the issue's up for debate, and you're entitled to an immigration bail. In this circumstance, because they arrested him at the border and sent him back, revoking his visa there on the spot, he doesn't even get those remedies, because they take the position that, oh, he was stopped at the border, he's not here, he's not being detained, he can just walk back to his country and everything's okay. But if you're detained here, he goes over to immigration, he goes over to the Henderson Detention Center, he gets an attorney who posts an immigration bond, and now he's free to wander on that immigration bond until the issue is resolved by the courts, and that could happen after the conviction in a circumstance. That might happen before, but nonetheless, in the states, that's generally the remedy that's provided if they're done here and then here on a valid visa. If it was a situation where he wasn't on a valid visa, he might not be entitled to an immigration bond, but with the valid visa, that entitlement exists, and so I don't see why the bond company would perceive that there would be an issue there. And that's, I guess, my bond company's position on this, Your Honor.
Well, they've represented Mexican citizens before who have come to the United States and been arrested. Has this happened before to the bonding company?
This is the first time something like this has happened. There are plenty of times where, my apologies, there are plenty of times where All-Star Bail Money has represented individuals who are nationals in Mexico who might have come here illegally. They posted the bonds, and when those individuals go back to Mexico, All-Star's fine. They pay up, they don't make an issue of it. And that's their position, because they knew at the time that it occurred what the problem was. They knew that there was an illegal situation. They knew that at some point, if he went across the border, he couldn't enter legally. They didn't want to encourage him to enter illegally, because they would be co-conspirators in that circumstance. And by allowing him to go back to Mexico, they put those restrictions on those defendants at that time. But, that being said, most of the time that doesn't occur anymore. Because now when the illegals go in and they are charged with a felony, or something that brings about what seems like it's going to be a mandatory deportation situation, Immigration and Customs places a hold on the defendant, and the only way you can post a bond is by asking special order of the court to be able to do so. Generally, the policy of the Clark County Detention Center is not to accept bail when somebody has an immigration hold on them. And so based on that, the bond is either not posted, or if the bond is posted, it's posted with the bondsman's knowledge that the individual might have a deportable situation on his hands. Absent that hold, there'd be no notification. I mean, the bonding company wouldn't know, and in this circumstance, they had evidence to the contrary. They had evidence of a lawful visa, and when a bonding company bails somebody out on a felony, they don't know how the case is going to resolve. If somebody's booked on a felony charge, quite often they're resolved to misdemeanors that would not revoke visas, misdemeanors that would not revoke immigration status. And in this circumstance, we'd be asking them to play lawyer and predict how the case is going to turn out at that point, whether or not they can cross the border again in these circumstances.
Counsel, do you agree that there isn't any condition listed in 178, 509, or 512 that would have permitted the district court to exonerate this bond?
I would not agree, Your Honor. It's our position.
What provision then would this court rely upon? Because our jurisprudence is pretty substantial that district courts are not allowed to exonerate except for exceptions, the listed exceptions, statutory exceptions.
I actually have 2 points to make on that. One, Your Honor, it's our position that he has been deported. If you look in our brief, and as it's stated in our brief, deportation is defined as the expulsion of one from another country, of an alien from the country. In this circumstance, we had an expulsion. There's also been some talk about forcible removal. And this is the definition that is is used by both us and the state in their responding brief. Quote, the act or instance of removing a person to another country, the expulsion or transfer of the alien from another country. First, it doesn't require the use of force. Nonetheless, if you use the use of force language, we have force. We have an arrest, we have handcuffs, we have an individual being detained, interrogated. Nonetheless, someone has been expelled when they have a visa, and that visa is revoked. They are told that they cannot come to the country. They're told that their application to enter will be withdrawn with sergeant's approval. Now, the state's going to come up here, and their position is going to be that he voluntarily withdrew that. And I pose that the circumstances don't lend to that idea. And the reason I say that is, if you read the record as it comes from the Homeland people, it's difficult to ascertain why, if he was voluntarily revoking his application to enter the country, it would require sergeant's approval or supervisor's approval. That's not something that normally occurs if it's a voluntary situation, especially when they're in handcuffs, interrogated, and then their visa's being revoked. He was open with law enforcement about why he was returning, but it's our position that we do have that expulsion from the country, forcible or non-forcible. He was expelled. When he entered, he came to the American side. They can't detain him on the Mexican side, so he was on American soil at the time that they detained him. He enters onto American soil, he's placed in the handcuffs, and then he's told he cannot stay here. He has to go back to Mexico, and his visa, his right to travel within America, or his privilege, I would say, to travel within the states is at that point revoked, and he's expelled, and his departure is at that point verified. So I would maintain the position that he has been deported, actually. That being said, it's also our position that he's been constructively deported if he hasn't been actually deported, because if this court adopts the definition of deportation to be a broader spectrum, and I would again pose that the definition that we list from Laxaw Dictionary in our brief is the same definition that's listed by the state of Nevada. And I just put that out there because I want to remind your honors that it seems to be an unopposed definition. But if we wanted to go with a more formal definition of deportation being one that goes through formal proceedings in a federal court, in order to revoke one's visa, there has to be some kind of formal process.
Is there anything he could have done to try to get back here? In other words, to revoke the revocation and reinstate the visa? How does that work?
Once it's been revoked, he has no actual rights at that point because he's now no longer a valid individual. He would have to go through the full process to apply for a new visa, which would be denied on the basis of the criminal charge for the very reason that they revoked his charge before. That they revoked his prior visa before. Now, the other point I wanted to make when we were talking about this court, and I do acknowledge that this court in Stewsville bonds does take a position that these bonds are governed by statute. And I think what's important to realize is that this court has also acknowledged in certain circumstances that when a statute is directory rather than mandatory, when the adjudicative function of the court is inherently threatened by legislative intrusion, there's going to be a little bit of deference given. That was referencing Waite v. Burgess, which was a 1952 case, and it was also mentioned in State v. American Bankers Insurance Company. And in that decision, the court said the decision to grant exoneration or discharge of a bond rests with the discretion of the trial judge, as long as the sureties do not aid in the defendant's absence. And the question then becomes, should contractual defenses apply? In this court, I think is universally held. Pretty much every ruling that's been given the opportunity to say that these are contracts. And then the question becomes, did the legislature intend to keep it pinned solely to NRS 178.509, or did they intend the contractual defenses to apply? And it's my position that they did, and here's why. By referencing NRS 178.512, it says the court shall not set aside forfeiture unless, and if you go to subsection B, you skip all the things that are on the list that reference back to 509, you go straight to subsection B, which is an oral type of situation. The court determines that justice does not require the enforcement of the forfeiture. And what we have is we have a situation where the bonding company was asking for exoneration based on justice, that justice which has been set out in common law as it's regarded to contracts. In this case, it would be prevention of performance by a third party, and also would be the legal impossibility, and it would be a supervening legal impossibility, because at the time the bond was posted, it was legally possible. The bonding company could insure his appearance because he was legally able to travel. At the time the United States government decided to revoke that visa, it became legally impossible for the defendant to appear in court, and it became legally impossible at that moment for All-Star to be able to do anything to get him back here in court and into the States. And I would posit that my client has had a great deal of contact with the family, and he would love to come back, but he cannot come back. If he did not want to come back, he would not have come to the border days before sentencing to do so. This is not a situation where somebody ran off to Mexico and was trying to avoid the possibility of being punished. This is an instance where an individual was coming back to fulfill his obligation to the state of Nevada as he put forth in the guilty plea agreement. And when you look at NRS 178.512, I think that's a clear legislative expression that they want justice to prevail in all of these matters. And I would submit. Thank you, Your Honors.
Okay, thank you, Mr. Sheets. Mr. Pace.
Good morning, Justice Hardesty, Justice Cherry, and Justice Douglas. Mr. Sheets, counsel for appellant. I'd like to start with the factual arguments that have been made and questioned by the court. What's clear is that the defendant in this case voluntarily went into a border crossing here in the United States. Now, the appellants made a big deal about the fact that that detention facility was on American soil. Where else could it be? There's no place in Nogales that's not either Mexico or the United States. So to provide a secure, comfortable facility in which they process these applications to enter the United States, they have to step on American soil. So it's kind of it's a non-issue, the fact that the facility is on American soil. It was his application to enter the United States, and it was his application to withdraw his application to enter the United States once they told him that they recognized that he had this felony case in Nevada. And the only reason they put him in cuffs is because the NCIC hit came up with this Nevada arrest, so they just put him in custody for officer safety. But one thing's clear is he withdrew his application and he walked out of that facility free to do everything he wanted to, including reapply to enter the United States. Now, he had appellate procedures, administrative appellate procedures when he was in the facility that he chose not to act upon. He chose not to make a call to an attorney. That's specifically mentioned in the report. And it's not true that he doesn't have other remedies to get himself back in the United States. First of all, he can reapply. He could have appealed at the time but chose not to. Plus, he also could take advantage of a significant public benefit parole, which is also available under the Immigration and Naturalization Act under Section 12. So he could apply. That significant public benefit parole is specifically designed for this situation where somebody wants to clear up criminal activity in the United States but are prohibited because the federal government finds them to be undesirable. So factually, that's not true. They can apply. Going on from there, so he basically walked out of the facility, free man to do many things, and it sounds like the bondsman's in contact with him, and the bondsman could have prohibited him under the contract from going back to Mexico. It's pretty much an industry standard to do that, to put that clause in their contracts. Whether it's in there or not, I don't know. It wasn't raised below, but it would surprise me if it's not already there. Let's go next to the use of the statute. They concede in their briefs that this is not a deportation, that the language is not deportation. So let's just go directly to the issue of constructive deportation. The law is clear. The statute has to be applied equally, and it needs to be a strict construction. The case law is clear. Whether you're referring to the cases of Wilshire or Harris or the prior case of All-Star Bell Bondsman, the language is clear. It's a strict construction of the statute. Now, whether they're strictly applying that to the state's argument or to the appellant's argument or the surety's argument, still all strict construction. For example, in Harris and Wilshire, the surety is arguing strict construction of the statute as applies to the notice requirements, notice of intent to forfeit. In the Stews Bell bonds, the state is requesting strict construction of the statute as applies to the definition of detainment by civil authority. So it's all, this court has consistently held it's a strict construction of the statute when you're talking about these Bell exonerations. So I encourage the court to continue to strictly construe the statute, because that's what the defendants, or the appellant's argument is today, is the appellant's asking you not to strictly construe the statute, but to go off on this constructive deportation argument, which is not found in the law, and it's inconsistent with this court's prior rulings. In fact, the appellate brief goes into an argument that Stews Bell bonds and Wilshire and Harris in that line of cases are inconsistent. I see them totally consistent, that that's the way the court's handled the interpretation of these bail bond forfeiture statutes. Turning next to the argument regarding the contractual obligations of the state of Nevada, it's clear that the state of Nevada was not at the border when the defendant attempted to and applied to re-enter. We did not turn him away. That's the state, or that's the government, United States government's duty, responsibility. We don't question that, nor do we take responsibility for that. I agree that the laws of contract do apply in bail bond situations when the statute is not clearly on point. The contractual law helps fill that out around the peripheries, but when you've got a statute on point, as this one is, strict construction says that this is not a deportation. The arguments made by appellant that the fact that the statute does mention deportation and detention by civil authorities gives some sort of intent by the legislature to imply this in all of the contracts just doesn't make any sense, because on that same theory you could find the state liable for people's deaths, mental illnesses, or physical ailments, which is not the intent of the state. The state's intention is to follow the statutory requirements regarding law. I regularly stipulate to the exoneration of bonds when people are deported. I regularly stipulate to the exoneration of bonds when people are dead, or any of the other conditions specifically mentioned. I've never stipulated when somebody has voluntarily went to Mexico or any other jurisdiction outside the United States and had, for whatever reasons, trouble coming back to the United States. It's not been proven, and I think that's the bottom line here, is it was the bondsman's duty, or that was the bondsman's burden to prove that the facts in this case fall within the statute. They never were able to prove that below. Judge Togliatti found that it was not an adequate argument, did not accept the constructive deportation argument, and found that the defendant had willingly decided to stay in Mexico instead of taking advantage of one of these other opportunities under the Immigration and Naturalization Act or under U.S. Code.
Was this argument made to Judge Togliatti below as to the ability to have alternate means to re-enter?
No, we never addressed that argument specifically. I reviewed the transcript and didn't remember it anyway being addressed, but she did specifically find on the record that he voluntarily exited the United States. If you have no further questions, I said what I need to. Thank you.
I don't think so. Thank you very much, counsel, for your arguments here today. We appreciate that. The case will stand submitted.